you make any notes of your assessment?
I wrote the risk assessment down, yes. Yeah.
No, but your notes as to what you were seeing?
No.
Why did you think it was appropriate for you not to be there when the work was being done?
I had a more important, at the time, engagement.
And in terms of the risk assessment, which is on pages 53 and 54, did you go through that risk assessment with Mr. Woodford?
I passed it to him. I passed him a copy of it.
Did you go through it with him?
No.
Mark saw me pull up and came down to meet me at my car where I parked. I put my safety boots on. He said he needed a high-vis jacket, so he went and grabbed me one from Chris's car. And then we went off to the scaffolding area. As I went up to the top of the ladder, we went round to see where Chris was working. Chris saw I was there, turned around, just said, hello, all right, and that was it. And he went back to doing his job. And we had to move a bit of, I don't know what it was, a piece of guttering, a roof sheet, I'm not sure. So Mark asked me to give him a hand. I don't remember much after that, I'm afraid. I woke up apparently having fallen through the roof with the paramedics around me.
So when you see the lad on the scaffold, why don't you say stop? Go back down.
Because I was busy.
How long would it have taken you to have said, go back down, wait for me? Should we say 5 seconds?
Yeah. Could the two accused, Woodward
and Bernstein.
whose actual name is Woodford, actually. It's really
We've got
annoying that we keep
handcuffs.
calling him Woodward.
Who's going to be the jailers?
Yes, we'll take them down after they've been found guilty. If you could just stand as directed here, please, whilst the proceedings take place. Ian, shall we hand back to you? Or?
Yes.
Thank you. Just if you go in the corner, that please. Don't be threatening.
Will the foreman of the jury please stand? Mr. Foreman, can you just answer my first question, either yes or no? Has the jury reached verdicts upon which you are all agreed?
Yes.
And on count one, do you find the defendant guilty or not guilty?
Guilty.
On count two, do you find the defendant guilty or not guilty?
Guilty.
Thank you. That's the verdict of you all.
Yes, it is.
Thank you very much. Thank you, Mr. Foreman.
Have a recap.
66 to 1.
If the defendants could keep quiet, please. Mr. Campbell, do you have any submissions before I proceed?
I just want to make sure they've paid my learned friend before they go down. I suppose now we'll proceed to sentence, and what I'm going to invite His Honour Ross to do, that sounds weird, is that if you can hand down this sentence appropriate under the basis that it was category A, harm, medium culpability, in relation to both defendants. First defendant has sole trader, turnover £70,000, so he's sentenced as an individual, which there means he can go to prison. Second defendant, company, forget what was the turnover I gave them?
3 million.
35.
35 million.
35
million. I don't know whether you want to explain it. I'll leave it to you, Your Honour. Okay.
Right. Would both defendants please stand in front of me? Thank you. Mr. Woodford, I'm going to deal with you first, and I'll deal with the company defendant secondly. Mr. Woodford, you've been found guilty of this offence, contrary to Section 3 of the Health and Safety at Work Act, and you've been found guilty on the clearest evidence which was put before the jury. I have to consider, firstly, how culpable you are, and it's agreed by the parties, and I don't disagree, that you fall into the medium culpability range, the medium bracket. Now, what that means is that the prosecution haven't proved that you had actual foresight of what was going to happen, or willful blindness to the risk of offending. But, and this is why you've you fall into this category. What you did was an omission which a person who exercised reasonable care wouldn't have committed. If you had exercised reasonable care, attention, supervision and planning, then this matter wouldn't have occurred, and Daniel would not have been injured as he was. I also find that you fall into the high level of harm category, category A of harm. And the reason for that is that the injuries which were suffered by Daniel were life-changing injuries. He was taken to hospital, he had to spend 8 days in the hospital, he had a brain injury, he had multiple fractures, and he's still receiving outpatient care, and we don't know how long that's going to go on for. So those were life-changing injuries which were suffered by him. The offence, in my view, is aggravated by several factors. The first one being you chose to take on a boy with no experience at all in the construction trade. Your evidence was that you assumed that he had experience, but there was no basis for you to think that whatsoever. You didn't bother to make any checks. You allowed the boy to come onto site without any induction, without even going down and meeting him and explaining to him what he could and couldn't do. Those are all aggravating factors. You allowed him, importantly, to climb the scaffolding, go onto the fragile roof, which I'm pretty sure, certain even, you knew was a fragile roof. You allowed him to go onto that fragile roof without a safety harness. You knew that there was no safety netting underneath, and therefore you exposed Daniel to a high level of harm, which is why you're in the category A section of the sentencing guidelines. Now, I have to tell you that the sentence for this offence, because you've been tried on indictment, which means you were tried before a jury, is an unlimited fine and/or 2 years in custody. I've been told that you have a turnover in your sole trading business of £70,000, and in my judgment, any fine which I could impose wouldn't do justice to the case, nor would it send out the correct message which has to be sent out in relation to deterrence, preventing other people acting recklessly in the way that you did. So in your case, Mr. Woodford, the only sentence which I can pass is a sentence of imprisonment, a custodial sentence. The guidelines which I have to have regard to indicate that there ought to be a minimum starting point of 12 months imprisonment and going up from there. In my judgment, the justice of this case requires a sentence of 15 months imprisonment. Now, I take into account the fact that this is your first offence. I also take into account the fact that you were a sole trader, and there are obvious pressures which you were under. And in those circumstances, I am prepared to suspend the sentence. So there will be a sentence of 15 months imprisonment. I'm going to suspend that for a period of 2 years. And what that means is if there are any further offences committed within that period of 2 years, that sentence can be activated and you would go straight to prison. Do you understand? So you can stand down. Now, Mr. Crouchley, your company, again, was found guilty in with the clearest evidence. You chose not to be present at the time that the contractors were on site. You delegated responsibility, which you shouldn't have done. You were careless as to whether or not the contractor was aware of his responsibilities. You couldn't care less as to whether the contractor's employees knew of the dangers which were involved and indeed you aggregated all your responsibilities and the offence was aggravated to that extent. As I said, the maximum fine is an unlimited fine. Your company has a very high turnover, and in my judgment, the correct sentence would be a fine in this case, and I fine you the sum of £850,000. So that's the sentence of the court. Yep.
It's amazing how you all went quiet when Ian started to give judgment, and that's how courtrooms feel like when a judge is handing down a sentence, or prize giving, as we refer to it as. I don't know if there's anything, Victor, which you wish to raise at all.
I don't know, I just wondered what, is in the spirit of engagement, what thoughts people would have on that. What do you think? Let's start with the fine, that level. What do you think of that? Yeah, one thing for turnover.
Not profit.
If you think, I'm sure this is the sort of magic document that Ian was using, and we'll use ourselves now, never far from it now these days, because you have to start interpreting things. And so a medium, let me see what a medium culpability is. I'm getting feedback now, it's like a spinal tap over there. So if you're looking at a medium type culpability, what sort of things are you looking at? Offender fell far short of the appropriate standard in a manner that falls between descriptions of high local systems in place but not sufficiently adhered to or implemented. So do you think that's what was going on with Arkwright? They were there, but they weren't implemented. If you go higher, it's failing to put in place measures that are recognised as standards. So not having those things in the first instance.
So what do you think for that rate of sentence? You've been higher.
Sorry?
Culpability. If you've gone to the higher level, would that make a massive difference to the sentences?
Yeah, it would have been another sort of section. I was given advice the other day to a large organisation, and we said, and for some reason they wanted to talk to their insurers. I won't tell them who, and they said, "Can you give us an optimistic level of fining?" And we're lawyers, we don't deal in optimism. So, I went through it and I said, well, we might be able to argue, they're saying medium, but we can perhaps get some evidence across if we get this and get it down to lower things. And it was 325,000. So then we went into conference on that, and they said, okay, I think we're ready for it now. Give us a pessimistic one. And so I said, well, all those things that they said, we're going to have to go up a few levels of culpability on that. We'll go to high, medium, so bordering onto that, because these are all sort of 50 shades of brown, I'm afraid, on this. But you go into that, and I said, well, your starting point, Ian started with a starting point with Woodford's sentence. Your starting point would be 2.4 million, which would go from 800,000 up to 6 million. So moving up those scales are quite something.
What's interesting though with the guidelines is that they're actually really badly drafted because they're based on turnover. And they were done based on turnover because basically rail track, Sellafield, Windscale all got away with blue murder. Now you know that you can be a business with very high turnover but very low profit. Or you could be a business with a very low turnover but a very high profit margin. Well, there's a case called MJ Allen, it's a Bristol case I think it was, where they're able to take into consideration future turnover and profitability. Because all cases, whether they're from these guidelines or not, still have to come under what's called the Magistrates' Courts Guidelines, section 164, which is that no fine can be imposed which is unrelated to the ability to pay. Now, this case, the analogous case to this one, took a day to sentence. The reason for that is that sentencing isn't about turning up and getting your prize. The documents which need to be provided to the court in response to the prosecution opening are very lengthy, dealing with each aspect of all the sentencing guidelines. Your company's accounts how many staff you employ, what the costs are, all those things become relevant to what is a very sophisticated sentencing exercise to ensure that first-time offenders are punished but not put out of business. But it makes it clear that for habitual offenders, the right course of action by a judge is to impose such a sentence to put them out of business. And if it is linked to your directorship, it is likely you will be referred to the Department of Trade and Industry or Business Innovation Skills or whatever they're called nowadays, because that'll probably change again next month. And you can end up being banned as a director. There are also ancillary powers of compensation, because what courts normally do, wise judges do anyway, and they tend to be what's called ticketed, so the judges are specifically trained. All of them at the magistrates court level are trained in environmental offences and health and safety offences, and there'll be in each court centre a particular Crown Court judge who will actually deal with these sort of cases. But what they'll often say is, it's a civil case. Yeah. They'll ring up one of the civil judges and say, look, I've got a guy here, guy's lost his thumb or lost his hand. How much are we looking at really in civil compensation? So his mate, the judge in the civil case, will go, oh, it's going to be X amount of pounds. So what the judge will go, oh, well, you're a wealthy company, you know what we'll do? £50,000 compensation, and I know it will come off your ultimate civil case, but actually haven't made a proper offer, £50,000 payable in 28 days to the victim family or to the victim, and you can still sort out the civil case at a later date. So, when you get into the territory of not paying fines, now there's something called the collection order added to every fine, as well as a victim impact surcharge or whatever. They can come round and sequestrate your assets, like that. They don't need another court order, because this is all about revenue gathering for the government. So they don't need any warrants or anything like that. You don't pay, you miss a payment on your fine. One payment. Even if you've doubly paid the month before, but if you fail to pay the next month, they will come round, they can take your assets. So, also, if as a result of any acts or omissions, you've done it for profit, which can be actually estimated, then they can go after you for that. There's loads of, it isn't just, this is just the tip of the iceberg. But so the repercussions for someone before the courts can be quite great. Sorry, because...
David, can you explain where and how the publicity orders come in within the sentencing?
Publicity orders?
Yeah.
That's in corporate manslaughter.
Yeah.
And they've been they use it very sort of sparingly. That is in the judge's armoury to actually, in a corporate manslaughter situation, is to dictate, you know, the company's been fined, and it's in page 6 of, you know, the I don't know, the Wimbledon Bugle, whatever. They can say, no, you're going to have to take up, pay for an advertising spread on the front page of the Daily Express or something. They can actually dictate that. But they've not used it. It's in their armoury, but they've not used it. I think I've come across one. There must be more, but I've come across one in that situation.
But on the non-fatal cases, you can guarantee that when the health and safety executive turn up to court, they already have their press release.
Yeah.
It is drafted from their opening, which they have handwritten and hand-typed and given to the judge. And the moment you walk out of court, all they do is just add in whatever financial penalty and it is in the press.
Yeah.
And you know the problem which you have in the trade is that there's a trade press. So although, you know, the Brighton Argus is tomorrow's fish and chip paper, when things get reported in the construction press or whatever, then that has a snowball effect upon your own reputation.
Yeah.
And then, of course, when you are applying for tenders for projects or government, for local authorities, and it says, have you been convicted of any offences? Are you? When you reapply for your insurance, you haven't got your no claims liability anymore. There's all those other little things for the want of someone putting down a widget gun.
And Chris will have a criminal record, obviously, even though it's suspended. And, you know, visa
He won't be able to go to Australia, to America, on a visa.
Yeah.
Unless it's Alcatraz.
I was just looking at your point, actually. I was just following up because, you know, the example I was giving was, you know, the optimistic and the pessimistic. So I was talking off the top of my head, but I did remember quite well. The optimistic one, low culpability. It's a large organisation, well over 50 million, so it would have been a very large organisation. So it would have gone from harm category 2 to harm category 1. But anyway, so it's the starting point would have been 300,000, which is my optimistic point of view, and then, but with a category range of 180,000 up to 700,000. So going on to the pessimistic one, which would be high culpability. So if we won all our arguments, it would go down to low culpability. This is in sentencing, because this would be after a guilty plea. We haven't decided yet what we're going to plead, but obviously these days, with these fine levels, people are making decisions on their accountants, not their engineering experts, on accountants' input. So if you go to high culpability, starting point, so 2 ones up, 2.4 million, with a range of 1.5 million to 6 million. So years ago, well, last year, or a year, 18 months ago, people would say, what's our chances? And you say, fair wind, 50%, you know, you do all right. And they say, well, okay, let's get in and out of the magistrates, keep it in the magistrates, we'll bumble along and we'll take it down and see. You're talking about 6 million people are saying, Christ, we're going to fight this every inch of the way. And also, one of the points the sentence that Ian was giving there, which was, I don't know, so is it the median culpability? So we've got the starting point there, 540,000, 300,000 to 1.3 million there, and he got there in the middle. This was a contested case. This was a not guilty plea. So again, a third off if you plead guilty in your at the first available opportunity, and that's another half-day discussion. The first opportunity, you get a third off. So a third off, 2.4 million. It's quite a considerable. So all these things are coming into the calculations of pleas, guilty pleas, and all the rest.
The sentence was based on a true story. Was these the sentences that were passed to these people?
No, the sentences were different. They were both financial penalties. They started off as imprisonment, but because of cooperation, plea of guilty, and that's the funny thing. The plea of guilty gives you leverage on submitting about culpability, harm, and actually having some mitigation and remorse and all those other things, shortening proceedings for the victims, etc. If you don't plead guilty and you are found guilty by a jury, judges will go to town to you and will then listen to your counsel on certain things. The problem you have is that on non-fatality cases, the district judges who are dealing with it, the health and safety executive, have a habit in certain areas of the country of not being totally candid in their documentation they provide to the court, and therefore assessing culpability and harm at a higher level than is correct. They fail to take into consideration the fact that it is not the actual harm, it's the risk of that harm. So as I said earlier, just because there's a fatality doesn't mean that the risk was of there being a fatality. There's a case called Tata Steel I referred to in the documentation, which is important. But funny enough, the Tata Steel case, there's a lot about the culture of the company and their fabulous health and safety record and the machinery involved in that one case and what they've done and all that sort of stuff. So, no, they got fined in relation to this case. Indeed, the company didn't. The company ended up with a warning from the health and safety executive because they didn't want to fight it, the health and safety executive. They knew they could get an easy plea in off the subcontractor.
Do we have any leniency at all on charities?
No, charities are dealt with as the same way as any other organisation now under the guidelines.
But they will take into account, you know, you go through these steps and then you look at things, then you look at proportionality and things like that, and then you have what effect it will have on that, and who are you punishing? You know, there was the old Milford Haven case, it's a pollution case, where we went back, we had 450, after the pollution, I can't remember the ship, it was in the HSE actually, and it was one of my refineries that I was inspecting. Ship went down, oil everywhere. The local authority were prosecuted in the shape of the Harbour Authority. They got, I think, a £450,000 fine. Nowadays, you skip out of court with that. But £450,000, they said, well, who are you punishing there? So the submissions there, you're not punishing the people who made a mistake, you're punishing, you know, the local taxpayers and things like that, the council taxpayers and things like that. So it was successfully argued down. So there are those arguments. I represented a trust up in Birmingham on a horrible fatality scolding case, and you know, we managed, and it sounds horrible, but you know, the language of lawyers and things like that, we managed to come out with a £10,000 fine, with the sort of who you're punishing. And that's the things you bring into play there.
But I also represented a company which had gone bust. There's 3 companies in the dock because of a fatality down in Cornwall. The 2 companies went bump, nothing to do with the case. It wasn't anything to do with, oh, we'll go into administration to save the monies. They still went after them, so I was representing the administrator for the company, and the judge still imposed a fine to market, although whether or not it would ever be recovered is another matter, but still handed down fine to £275,000. Why did they still go after them? It was to make sure that the company was solvent, didn't blame it on the other 2 companies. Because what you do as a prosecutor is you rail in as many people to stop them all from pointing the fingers at each other. Because if you drop someone out, they can go, oh, it wasn't me, it was them. And there was a lot of legalities over that, but the legal mechanisms, because the banks who forced them to go under were in Ireland and all this sort of stuff, but in the end, the administrator says, well, I can't pay this money, that's all you can't, but that's the fact. £275,000 fine. But, so they will go after you even if you go bump.
And it's a very dangerous thing for directors to say, right, I'm going to go out, because then they come after the directors.
Yeah. And if you go bump to avoid criminal prosecutions as a company, you will be disbarred as a director. Yeah, it's as simple as that. And they probably won't even do it by way of an undertaking. They'll probably give you a straightaway 5-year.
I can remember receiving the summons on behalf of a client, and the policeman actually came and delivered it himself. I think he was enjoying it too much. But he came and he said, well, Richard, he said, I know you told them not to go into administration, but they wouldn't listen to you, so there is individual summons. There you are. Give that to him, he said.
Yes, sorry.
So, for example, is there a discretion for the judge if there's a group of companies or the company decides to create loads of subsidiaries to reduce the overall turnover for each individual company? For example, you share director, so it's obvious that it's an exercise to...
If a judge feels as though they will hand down a sentence which they want to hand down, and they will say, if we've got it wrong, you can go and appeal us elsewhere. And if we think that you're trying to hide behind companies in order to avoid culpability, they'll take judicial note about that, and that would be an aggravating feature.
Yeah, it'd be quite a serious matter.
Yeah. Yeah. Well, ladies and gentlemen, thank you all for your time. I'd like to thank Richard and Ian for joining me today and for all the work they've put in on this. We hope that you've enjoyed it. You know, as what they say at Crime Watch, it's actually a really safe place, England, so don't have yeah.
Never seen it.
Never
watched Law Things.
Can we thank all the witnesses in this case who've done a really, really good job. We'll give you your equity cards later on. Just at the Playhouse Theatre around the corner later on. But thank you all very much. Thank you for engaging, and we'll go out for a drink if you want to catch up. Any issues you've got or anything, contact A.C.T. or Aon or whatever. They are able to provide bespoke day-to-day assistance to you. If you don't ask, it's always, I always say to clients, just ask me the questions. Don't ask me afterwards when we've walked out of court, oh, Mr. Campbell, is this important, yeah? 9 times out of 10 it might be a stupid question, but 1 time out of 10. And that's what A.C.T. provides, a bespoke service to companies. And Aon, thank you very much for your hospitality and your support in this venture. I hope it's been worthwhile for you all. Thank you.
Thank you, David. Thank you, David. Thank you, Richard. Thank you, Ian. Particularly like to thank Richard for getting a reference to spinal tapping. That was very good.
All right.
So as David said, yeah, thanks to all the players, the A.C.T. team. Thanks to Aon and to Event Industry News for their sponsorship. We hope you've had a great day. We will be doing some more of these in the future, so if you did enjoy it, tell your friends. Just for the record, the verdicts were 66-1 and 65-2, so it's fairly convincing. Whoever the 3 people were who voted not guilty, I admire your courage. Thanks again, and there will be drinks in the smoking room if you want to have a few moments before you leave. Thank you very much.